Contract law. It's usually a subject that you learn for full semester, usually 5 hours a week. We'll try to finish it within 2-3 hours. So pay attention. Repeat after me when I say something loudly. Contracts. So the term contracts means something binding. So it's much more stronger than a promise. Okay? Now agreement is more like a form of a contract, right? So you enter into an agreement. You sign an agreement. Agreement is more about a physical or procedural thing that makes up a contract. But contract is the substance, right? Now, contract is about holding someone accountable for a promise that he or she has made. Now, torts is not about a promise. Torts is about a wrong that he or she has committed. So contracts starts out with questions about when there is a contract. So repeat after me. Formation. So there are 3 different elements, each of which has to be satisfied for a contract to be formed. First is offer and acceptance. Repeat after me. Offer and acceptance. So there has to be offer of the terms of a contract, and there has to be acceptance of those terms. That's where the contract law begins. If there is no offer and acceptance, there is no contract law. You are not in the area of contract law. The second requirement for a contract to be formed is capacity of the offering party and accepting party. Repeat after me. Capacity. So capacity, so the offering party and accepting party has to have capacity to do so. I'll talk about this more in detail. The third, consideration. Repeat after me. Consideration. Consideration is one of the most frequently mistranslated terms in American law. Has nothing to do with the perio or Kuocw, but it is best translated into 대가. Okay? So Anglo-American contract requires consideration. Contract without consideration is considered void. Okay, that's one difference with civil contract law. Now that there is a contract formed, the next question that comes up is, when was it performed correctly? Okay, so the next set of questions you should worry about is performance. So repeat that with me. Performance. Of course, this question arises only after a contract is formed. Okay. Now, if a contract has been performed, if a contract was performed as agreed to, then there is no issue of contract law because there is no dispute. But when contract is not performed, 3 different scenarios can arise. Okay? So it can be a situation where a condition of a contract has not been satisfied. Okay? Or it can be a situation where contract is formed and condition for contract has been satisfied, but the parties' obligations to perform the contract are discharged. Okay? So condition can be translated into 선행 조건, 이렇게 보면 되겠죠. 또는 후행 조건, 계약 성립의 조건을 말하는 겁니다. And discharge, 이거는 면책. 네. 그러니까 계약도 성립됐고 계약 성립의 조건도 다 충족이 됐는데 그러면 그때 계약을 이행 안 했는데도 불구하고 용서가 될 때가 있어요. 네, 이런 걸 이제 discharge situation이라고 하고. Okay, if there is a contract that has not been performed, whose condition has been met, whose obligations are not discharged, then that contract must be deemed breached. Repeat after me, breach. Okay. So the three things, condition, discharge, breach, are not the elements of performance. Okay. Those are the situations that can arise when the contract is not performed. The third set of now that contract is breached, okay. Now that contract is breached, then we have question about remedies. Repeat after me, remedies. So what is the non-breaching party entitled to as remedies is the question. And there are three different remedies. First is damages. Repeat after me, damages. It's not just 손해, right? It's 손해배상, as you learned in your torts class. Okay? It can also mean 손해, but among lawyers, it usually means 손해배상. So damages is one. Also, another remedy is termination. Repeat after me, termination. So ability to terminate the contract is one remedy given to the non-breaching party. The final remedy is injunctive relief. Repeat after me, injunctive relief. Injunctive is adjective form of enjoin, right? Not enjoy. Okay, enjoin means order someone to do something. Okay, so you never say like I enjoin you. Okay, I enjoin you from doing something, which means you are prohibited from doing whatever. Okay? So injunctive relief is a court order preventing a party from doing something. That is injunctive relief. Okay, so this is the total table of contents. This is what the American law students spend the full semester on. Okay, these 9 concepts. And if you know 9 of these, then you are set. Terms. Words, phrases, phrase, clause, sentence, subparagraph, paragraph, section, article, chapter. Okay. You see the order of the things, right? You start from small and you move to bigger things. What's the difference between phrase and clause? Anyone? Which one is bigger, phrase or clause? Clause, okay. Is it just the size, or is there some other difference?
Huh?
Whether there is a verb or
Verb or not. Okay, almost, right. So which one has verb? Huh? Clause, yeah. So clause has a structure of subject and verb, right? Subject and predicate. Subject and a phrase can have just nouns. Actually, phrase may just have verbs, so you are wrong. Clause is different from phrase because clause has subject and verb, right? So it has the structure of a full sentence, but it's just not a sentence, right? That's a phrase, that's a clause. Sentence, subparagraphs, paragraphs, section, articles, chapters. And you call this, you call the higher units starting from subparagraphs to articles, you call those provisions, right? Provisions. Life of a contract. How does a contract begin? Execution. What is execution? How do you translate execution of a contract? What does it mean to execute a contract? It means sign a contract. So if sentence goes like execute and a document comes as an object of execution, then that means signing. It's not about performing. 집행하고 그런 게 아니죠. 서명한다는 뜻입니다. execute하고 뒤에 문서가 오면. Execution, and when you execute a contract, you usually enter into a contract. So entry. Okay. So execution, entry, signing, all of this usually takes place first, and then it moves on. But that doesn't mean that contract is effective immediately. There are times the effective date is delayed. So that's why effective date comes later. Effective date means the date that contract becomes effective. Okay? And after the contract is fully formed and effective, there is a performance. And when does a contract die? There are three different ways for a contract to die. There are three different ways of terminating a contract, right? It can have a natural death, that's expiration, okay? Or it can have it can be undone, okay? It can be undone and brought back to the pre-signing stage. Okay, it can be returned. The parties can be returned to the pre-signing stage. That we call cancellation. Repeat after me. Cancellation. A more loyally term is rescission. Repeat after me. Rescission. Okay. So when you are, when you enter into a contract to buy a house, but something happened and the party wants to just go separate ways and never finish the sale and purchase of the house, then that's rescission. Okay? But what if there is a employment contract between two parties and later the employee wants to leave? So contract needs to be terminated. Okay, that's termination. Okay, that's the narrow meaning of termination. The broader meaning of termination includes, 그러니까 종료라는 의미에서는 it includes expiration, cancellation, rescission, and the narrow meaning of termination. And narrow meaning of termination is ending of a contract without returning the parties to the pre-signing stage. When an employment contract ends, does the employee return all the wages that he has received? No, right? So the relationship that existed, that has existed up to that point, is recognized as valid, right? So that's the difference between rescission and the narrow meaning of termination. Does this kind of ring a bell for you? If you know, in regards to what you have learned in your Korean law class? Right. And I think it's almost, 해지 is almost like the narrow meaning of termination, and 해제 is almost like cancellation. But there are scholars who believe that they do not align exactly, right? They do not, the correspondence is not exact one-to-one. So I hate to, so I'll be careful to just, you know, call rescission 해제 and call termination 해지. But for most purposes, I think you will be fine. Okay, contracts. Does your PowerPoint also have Korean phrase in it? Okay, all right. Let me just double check. Okay. Okay, so the first element of formation is offer and acceptance. You have learned this in your Korean law class. What is it? Okay, good, good. And you all know that mirror rule usually applies, where the offer can be accepted only by acceptance that has exactly the same terms. Okay? If you change even one provision, if even one provision doesn't match between offer and acceptance, then there is no offer and acceptance. There is no complete offer and acceptance. Okay? Now, in your real world, offer and acceptance takes the form of these documents. Repeat after me. Purchase order, pro forma invoice, offer sheet, or sometimes invoice. Invoice. Yeah, so pro forma invoice is before money is requested. So it's like estimate. So this is how much you will pay when you are delivered the goods and services. The document informs the other party how much the person will be expected to pay. And invoice is when the money is due, right? Invoice the document requesting the amount. And exchange of these documents can easily become offer and acceptance, so should be very careful. But the titles don't matter. The titles really don't, I mean, even the documents that have title, that don't have title like offer and acceptance, I mean purchase order, pro forma invoice, offer, even those documents that, even nameless documents can constitute offer and acceptance. Okay. Just one trick question. Let's say there was a negotiation with your opposing counsel for 2 months over a contract, and you discussed over email on each clause, each phrase, each provision, and the parties believe that they have reached an agreement and it's time for signing. So you ask the opposing counsel to sign the contract and send over so that it can be countersigned. Okay? Countersign means a second signing, or the having the second party sign. Okay? So you receive through DHL or some expedited delivery service a signed copy of the contract, and as you read through, there is one provision. I mean, it's a 100-page document. It's signed properly, but has one provision wrong, or at least not according to your memory, right? So, but it has to be signed, within 24 hours, or the agreement has come into being within 24 hours, and you don't have time to have the party send in a new one, right? Send in a corrected one and sign again, and you don't have time to create a whole new copy, sign, and send to the other side for it to be countersigned, right? So you just correct that provision, right? And then do the counter signature and send it back. Is there a complete offer and acceptance? Simple answer is no. Okay? No, because offer and acceptance doesn't match, right? Now, about this, to save time, instead of having one party sign first, send over for the second party to sign, instead of doing that, both parties sign the identical copies and exchange, right? Do we have offer and acceptance? Assuming that the copies are identical. The answer is yes. Okay, as long as there is the ceremony of entering into a contract where the terms of offer are identical with the terms of acceptance. Doesn't matter whether it is signed on separate sheet of paper, or whether it is signed not by signature but just by simply typing in the name, or by putting a Korean seal, 도장이죠, over it. It doesn't matter. The question is whether there is a proper ceremony, and at the ceremony the terms of offer are identical with terms of acceptance. Okay. Now there is an exception to the mirror rule. There is an exception to the mirror rule that comes from Uniform Commercial Code that applies to merchants. 그러니까 상행위를 업으로 하는 사람들에 대해서는 반드시 미러 룰을 엄격하게 적용하지 않는다는 규칙이 있지만, 지금 그것까지 다 배울 수는 없고 우선 원칙은 이렇다라는 것만 하고, 여러분들이 주로 다룰 그 계약서들은 100페이지, 50페이지짜리, 30페이지짜리 계약서들이기 때문에 그런 것들 서명을 가지고 그런 유니폼 커머셜 코드 머천트 익셉션이 적용되진 않기 때문에 그 부분은 지금 다루진 않겠습니다. Alright, the second element is consideration. Repeat after me, consideration. I told you there has to be consideration for each contract, which means there is no such thing as gift contract under Anglo-American law. Okay? So if I enter into a contract that, well, if you and I enter into a contract that I'll give you $1 million at the end of this year, on December 31st, I offer you the term, you accept it, then there is a valid offer and acceptance. That doesn't mean that the contract is effective. If there is no consideration for my giving you $1 million, then the contract remains void. On what possible ground do I need to give you $1 million? Right? There has to be some exchange. So if I don't give you $1 million as the contract says at the end of the year, and if you sue me, what happens? If you sue me for breach of contract, what should happen? Huh? Okay, well, first thing first. You win or lose? You lose, right? You lose, and you lose on, now you learn the civil procedure. You lose on what, at what level? Yes, you'll be dismissed. You'll be dismissed out of court very early. Okay? The court immediately, the judge will, or the defendant, or my lawyer will immediately bring a motion to dismiss, and it will be granted. Okay? Now, the exception to the requirement of consideration is promissory estoppel. Okay? Promissory estoppel is kind of a tort. It's not a contract cause of action, it's tort cause of action. This is when parties mislead. What happened here? Okay. This is when parties mislead one another well, not when parties mislead one another into financial damage, because when you actually mislead the other party, that's fraud, right? But promissory estoppel is not fraud, right? Let's say, okay, let's go back to the $1 million contract, and in relying on my promise of $1 million, let's say you entered into other contracts, like you entered into a loan contract to borrow another $1 million from a bank, and then you entered into a construction contract to build a $2 million building, right? Now, in relying on my promise, you do all these things, and then if I don't perform the contract, if I don't deliver that $1 million, then you will suffer damages, because now you will have to cancel all those contracts. Okay? Then you will suffer damages. You will suffer damages in having to do what of your loan contract or your construction contract, having to do rescission, right? Now you have to cancel those contracts, and you will suffer damages. You can hold me liable for irresponsible actions of not delivering my promise, but that's not a breach of contract. Okay? And damages will be different. Okay? In that lawsuit, you'll be able to recover only the administrative cost of entering into and coming out of the loan contract and this other contract, construction contract, if it had been a breach of contract lawsuit, the damage would have been greater. Okay, you might be able to get $4 million from me if that's what I promised. Okay, so promissory estoppel is not really an exception, but it's something that it's a remedy that a party disappointed by a promise not fulfilled can have against the promisor. Okay, you know what's meant by promisor, right? The person who has promised. Okay, all right. Now, so we took care of two elements already: offer and acceptance, and consideration. The third element is capacity. So the person making the offer and the person accepting that offer has to have legal capacities to do so. Well, when do you not have legal capacities? Well, minors typically don't have legal capacity. You learn all this, right? Minors. And insane people, they also don't have legal capacities. And in some countries, some jurisdictions, people who are imprisoned also have no capacity to enter into contracts. Okay, those are easy ones. What we are about to talk about is a more difficult one. How about in a corporation, in a company? Who has the capacity to enter into a contract? I hear this a lot. I heard this a lot when I was working for a law firm. So there is a big contract negotiation. It's all done. Now just the signing ceremony has to happen somewhere in Los Angeles, California. But CEO doesn't have time. All the officers don't have time. Even the managers, 보통 매니저 하면 이제 과장을 얘기하죠. Managers don't have time. And the only person who has time is really the bottom employee, the bottom level employee who doesn't have much authorities within the company. And my client company asks me, oh, nobody can go, what can we do? Well, can they send a secretary to sign the contract for the company? Yes? No? You also learned this in your Korean law class. Can a bottom level employee represent the employer company to sign a contract?
He has right power to represent the company.
Okay, how does he get? Well, that's like just asking the question in the different sentence. So does he have the power?
When the CEO given the right power.
Exactly, right? If there is express delegation, that's why it's meant. That's why it's called express authority. If there is expressly delegated power, anyone can go to the signing ceremony. Okay, the answer is right there. Okay, and then another way of getting that power is implied authority. So authority can be implied. So authority doesn't have to be given expressly. It can be implied from the job and the hierarchy of the person signing the contract. For instance, when the school buys this chair, right? Do you think that the university president, who is the legal representative of our school, do you think that the university president has signed the contract himself? No. Do you think that the university president has expressly delegated somebody to buy this chair? No. Right? Some things are authorized in implication. Okay? Some powers can be implied from the job and the hierarchy, the hierarchical position that the signing person has within the company. So the procurement department, 이제 구매 담당, 구매부라고 하죠. 구매처에서 이런 거는 알아서 샀겠죠. So that's implied authority. Now, there is a third way that power can be imputed to your company or the signer for your company, even if your company doesn't want it. Okay? That is apparent authority. Apparent is adjective for the verb appear. Okay? So when it appears that the person has authority to sign the contract, then the company is bound to that appearance. All right? Even if that person really doesn't have the authority. Okay? So this has happened really. So there was so this is the U.S., this Korea, and film distributor, 영화 배급사죠. Could not hire somebody in the U.S. Okay, could not hire somebody in the U.S. But didn't want to just have somebody, some outsider, represent the film. So the film distributor's job is to go to the U.S. and take early look at the films made or to be made, okay, about to be made in the U.S. and enter into contract to buy them, buy exclusive rights to distribute that in Korea. Okay, that's what film distributors around the world do. Okay, and so to compete against other film distributors, it would be nice to hire somebody, have an employee in the U.S., but usually the companies don't have money. So the other option is have an outsider represent the company, but that's usually not so attractive to the film producers in the U.S. So I'm buying films for CJ International, and then if the person gives out a business card of some other company, it doesn't inspire sense of trust, right? It doesn't. There is a bit of a reluctance to do business through an outsider. So the Korean distributor took an easy way out. didn't hire, but just contracted with one person, but gave him the title of vice president on a business card. So the film distributor made this business card that says VP and Richard Kim. His name was Richard Kim, actually. There are many Richard Kims, so don't hold any Richard Kim responsible for this. Richard Kim that you know. And he has done a good job of getting the films for the Korean company for a few years. And whenever he enters into a contract, he checked with the home company the pricing and the content of the film. So things were fine. But 1 year, this VP entered into, I even remember the name of the American, Summit Entertainment. This was the American film distributor, and he entered into a contract with Summit Entertainment without consulting with the Korean film distributor at all. Okay? Entered into a contract for $1 million to buy this film, which the Korean company didn't want to buy, never wanted to buy, but this VP just entered into a contract. Now, there was no express authority to buy this film. There was no implied authority to buy this film. So this VP did not have any authority to enter into a contract. So in reality, since there was no authority, is this contract valid or void? It should be void, right? If we are talking about only express authority and implied authority. But the reason that the Korean company is bound to this contract and this contract is valid is because of apparent authority, right? If the principal 이제 주인을 얘기하는 거죠. 주종 관계할 때. If the principal has built up the agent, right? Built up another person to appear as if he or she has power to enter into certain contract, then the principal is bound to that contract, even if the principal knows nothing about it. So that film. So, what do you think happened afterwards? Well, the Korean company had no option. They had to pay $1 million for this film. The film came into Korea. It made no money. Yeah. It was a complete flop at box office. Okay, now, having said that, the question is whether it was reasonable for the third party to rely on the appearance of the authority. Okay, rely on the apparent authority of the signer, right? Now, having said that, let's go back to the first example of sending somebody to the signing ceremony. Okay. Now, from this company's perspective, whether we send a secretary or CEO, as long as there is express authority, or if you send somebody whose job and hierarchical position comes with some implied authority to sign the contract, then that's fine, right? It's fine for us, right? But what if the other side shows up with the secretary and he claims that he has authority to sign the contract? Would you sign the contract there with the opposite side represented by a secretary or another low-level employee? Would you go ahead and sign the contract? By going ahead, you are risking the following. What if the other company later says, oh, we never sent him. He never had the authority to sign the contract, right? And his job and hierarchical position do not give him power to sign the contract, right? So we call this repudiation. Repudiate. What if the other side later repudiates the signing of the contract? What can you do?
Well, you can claim that there was a parent authority regulating.
Sure. But that has to be reasonable, right? That belief has to be reasonable, right? I mean, the first thing you have to do is, you have to prove express authority or implied authority, but you are not in a very good position to do so because it's the other company. You know a lot about your company structure. You know a lot about whether there was delegation, right, within your company, but it's really hard to prove whether there was express authority. I mean, authority can be given over a phone call from a CEO to the low-level employee, right? If the other company says, oh, the CEO never made a phone call, how will you prove that there was a phone call, right? It will be extremely difficult. So it's safe to make sure that signer of the other side has apparent authority that you can rely on, okay? Apparent authority that you can rely on in holding the other side responsible for the contract. Okay? That's why, although I advised my clients that, well, theoretically you can send anybody, okay? You can send anybody to form enter into a legal contract. If the other side demands to send somebody higher that has apparent authority, then you will have to accept it, and I'm talking to my client, you also will have to demand the same from the other side. So in the end, high officials end up at the signing ceremony. But that's not because they have no inherent powers. That's not because low-level employees have no inherent powers to sign the contract, but it's just to reduce the risk of a contract being repudiated later. Any question, comment on this? All right. If a contract is formed, now it has to be performed. But there are those contracts that don't have to be performed yet. The contracts that have conditions attached to their existence. Okay? And those conditions can be precedent and subsequent. Repeat after me. Condition, precedent. Condition, subsequent. So if neither of the conditions is fulfilled, then the contract is cancelled, even if it has been signed. Okay? So typical condition precedent to a contract formation, okay, a typical condition precedent to contract formation is delivery of the signed contract to me. Okay? That means, let's say there is a contract and fully negotiated, not signed yet, and the other side has signed first, okay? And let's say the signed contract was delivered to me and I signed it, okay? Now, if the contract has a provision that says this contract is subject to condition precedent that the countersigned contract is delivered to both sides, right? Then upon my signature, has the contract come into being? Is there a contract as soon as I sign it? No. Okay? It has to, the formation is delayed to the point when the delivery is made to both sides. Why do you think that the parties will want to have this provision in the contract? I mean, this is just one example of condition precedent. Okay? Why do you think the parties will have a provision like that in the contract? To control the time of contract formation. Again, this has happened. So here was a Spain film distributor, and here's a Korean film producer. And they entered into a contract where they'll pay money to distribute the Korean film within Spain, right? Entered into a contract, and this contract, so it's fully negotiated. So, Korean film producer is happy that they can make money on the film. So, send a signed contract to the Spain film distributor. But after the signed contract was sent over, the Spanish film distributor just disappeared. Doesn't respond to emails, doesn't respond to calls, just disappeared and has not paid any money. Well, later, the Korean film distributor travels Spain and finds out that this Spanish film distributor is selling DVD of the Korean film already. Okay? Now, what would you do? You're loyal. What would you do when your client finds unlicensed DVDs being made of their film in a foreign country? Well, this is copyright infringement. Let's assume that it's copyright infringement, right? Well, you will go to Spanish police to demand investigation. But then again, copyright infringement is not usually criminally prosecuted in other countries. It's only Korea where copyright infringement is dealt with so severely. So, okay, forget about criminal law. So, right, let's sue the company for, copyright infringement. But do you know whether it is really copyright infringement? What if the Spain film distributor has received a signed copy and has signed it himself, okay, and maybe send it to the Korean film distributor, but on the wrong address or something, right? I mean, if you spend tons of money to hire a Spanish lawyer to sue the Spain film distributor, but only to later find out that Spain film distributor has countersigned the contract signed by both parties, that will be waste of a lot of resources. Not just that, usually film distribution contract comes with an arbitration agreement. I'll explain to you later, but arbitration clause, despite a lot of bad publicity given to arbitration, it is, I believe, the most efficient and the most economic way of resolving commercial disputes. I recommend arbitration to all the clients interested in efficient dispute resolution. But the problem is that there are many clients who are not interested in efficient dispute resolution, especially big companies who want to just overwhelm smaller companies with their legal resources. They don't care about efficient resolution. It's better for them if disputes are not resolved efficiently. Those companies don't need arbitration, but if clients want efficient dispute resolution, arbitration clause is very useful. It's usually in there, and okay, here is a dispute, and your client, Korean film producer, wants to make use of arbitration clause, but guess what? We don't know whether that contract has been signed, right? Because to go to arbitration, there has to be valid arbitration clause that both parties agree to. But because Korean film producer did not have knowledge of whether the contract has been signed or not, they could not make use of the economic dispute resolution process. I mean, what's good about arbitration is you don't even need a local lawyer. You can hire a cheap American lawyer to represent you in Spain. Okay? But they cannot benefit from the arbitration clause. So, all of this could have been avoided by what? Having a provision that says condition precedent to formation of this contract is delivery of signed copy to me, to the Korean film producer, right? And the contract will become valid upon the point of delivery, not before, right? Okay. Now, that's only one example where there is a condition precedent. Now, there is such thing as condition subsequent as well. Usually, government approvers, when the contract needs a government approval to be performed, usually the parties attach government approval as a condition subsequent. Okay? So it works like this. Let's say contract is signed. If there is a provision that says government approval within 30 days is condition subsequent of this contract, then as soon as it's signed, it is a valid contract. It stays valid 30 days. Now, on 30th day, if 30th day passes and government approval has not been obtained, then it becomes nothing, right? If there is government approval, then it remains valid from that point on. Okay? Yes?
So by nothing, you mean the contract is cancelled?
It's not even cancelled. Yeah. I mean, if the parties do something, it will be called cancellation. But even without cancellation, it just becomes void automatically, because the contract itself says it will. That you put some condition subsequent means that if condition subsequent is not fulfilled, the contract becomes nothing at that point. The parties don't really have to do anything. I mean, if there's a dispute, one party will have to do something, and that action will be called cancellation. But you don't even need to do theoretically, you don't even need to cancel it. Okay. So government approval. Yes, it remains on. If government approval no, then it has to come down. Now, if you compare it to condition precedent, there has to be so it's signed. If the condition precedent, if the government approval is condition precedent, what happens? Upon signature, does it go up or remains down? Yeah? It should remain down because it is condition precedent, which means the condition has to be fulfilled first and the contract becomes valid, right? So it remains non-existent, and at the point of government approval being obtained, it becomes a valid contract. Okay? Now you see the difference between condition subsequent and condition precedent. Now, if government approval is not obtained, then of course it keeps, it remains void. What's the only difference between making government, what's the difference between government condition being attached as a condition subsequent and government approval attached as a condition precedent? The treatment of the contract between this period. Okay. Now, let's say for whatever reason, the government has the contract has been signed. Government and the parties are in that 30-day period waiting for the government approval. What if one party just had a change of mind and wants to just cancel the contract? Is that breach of a contract? The party had a change of mind. Well, let's say you enter into a contract with another person to get married, okay? But only after 1 year has passed. So passage of time is the condition precedent. What if you have a change of heart in that 1 year period? Okay, if marriage is a too remote a subject, can think about other things. let's say, you know, you are selling your notebook computer, but you make it a condition that purchase contract becomes effective only if you pass the bar exam, okay? Because now you don't need the computer, because firms will buy for you, right? Can you just repudiate the contract because you just had a change of heart and suddenly like your computer, your notebook computer so much? Is there a breach of contract? No, right? Because if it was a condition precedent, at this time there is no contract to breach. Okay? That's why all those government approvals usually come in as condition subsequent. Because if it comes as a condition precedent, what will happen? The parties will just, you know, repudiate the contracts freely without any consequences. But if you make the government approval condition subsequent, the parties are bound to the contract until it is obtained.
Even in the condition precedent,
Mm-hmm.
if they repeat it before it is validated,
Mm-hmm.
isn't it the promissory estoppel?
Possible. That's nice. That's what I was going to talk about. Yeah. That can be promissory estoppel. Estop means, estop은 이제 estop. 부인할 수 없다, 이제 이런 뜻이죠. So you are estopped from repudiating your promise. Okay, you are estopped. So that's why it's called estoppel. So you cannot be estopped from repudiating your promise. Okay, so yes, here there is no contract, but by making a promise, you mislead the other party into doing things, then when you repudiate that promise, you have to be responsible for the damages that you have caused. Okay? And, you know, this will be this will be like, you know, intentional tort, right? Because you are consciously repudiating a promise that the other side has relied upon. Okay? But only if you know that the other side has relied on you. Okay. And then there is a pseudo condition precedent and condition subsequent, which means fake condition precedent, condition subsequent. What I mean by that is it's not really a condition to the existence of a contract. It's a condition to performance of a contract. The most frequent sightings of conditions to performance will be something like this. Condition precedent to, like in a mergers and acquisitions contract, 그러니까 M&A 계약서에 보면, so all mergers and acquisitions are composite of share purchase agreements. Share purchase agreements means 그러니까 주식 양수도 계약서인 거죠. 예. 그래서 모든 M&A 계약서를 다 이렇게 쪼개보면 그 가장 기본적인 단위는 그거는 주식 양수도 계약서예요. 주식 양수도 계약서를 이렇게 몇 겹으로 쌓아놓기도 하고 서로 주고받기도 하고, 그리고 당사자들이 뭐 대주주 또 회사 그래서 그런 것들 구조를 복잡하게 만들어도 하여간 기본 단위는 주식 양수도죠. 근데 주식은 it's just a piece of paper, right? And nobody knows, how much value that piece of paper represents. So when you purchase shares of a company, you always have to require financial statements of the company. So in any share purchase agreement, you will have this clause. Condition precedent to purchaser's obligation is delivery of financial statements. In a share purchase agreement, what is purchaser's obligation? There is only one obligation of the purchaser. What is it? Pay money, right? And the obligation to pay money arises only when the financial statements are delivered. Now, that's only one of the condition precedent. There can be, I've seen as many as 25 condition precedents to purchaser's obligation. Yes, that's what lawyers do. Make people's lives miserable, right? So by attaching 29 conditions precedent, the seller's company will have to prepare all the documents. So that's the seller's, that's one of the biggest jobs of the seller side lawyers, preparing condition precedent documents. And some of the condition precedent documents are, summaries of the lawsuits that the companies are involved in, okay, or summary list of board members, records of any tax delinquencies or tax non-payments, or any wage non-payments. Those things are all called condition precedent documents. But that really doesn't affect the existence of a contract. Okay. So in that sense, it's not really true condition precedent or condition subsequent, but you'll hear that term a lot more often in that setting, in that merger acquisition setting. And you'll hear lawyers 선행문서 준비하느라고 밤을 샌다 이런 표현을 많이 들을 때 저런 걸 얘기하는 건데 실제 그 계약의 효력에 영향을 미치는 건 아닙니다. So, to drive the point home, let's say the condition precedent has not been satisfied, right? So the financial statements were not delivered. Can the purchaser just cancel the contract? Because condition precedent documents were not delivered? No, because contract is already formed, right? Now, what is conditioned by the delivery of financial statements is whether purchaser will pay money, not the existence of the contract. So the contract is still valid even if the financial statements are not delivered. Purchaser will just have to wait, right? So that is the difference. Okay. I went over time just a little bit to make up for the shorter class that we had earlier, and I'll do that a few times. Then that will make up, the time loss without having to schedule another class. So, okay, I'll do more lecture next week, and then we'll go through these three cases. Livingston versus Evans, McAfee versus Brewer, Case 3, Harrington versus Taylor, Rose versus Elias. Okay. We're not going to do Pickwick's food store. We'll just end at Rose versus Elias. Okay. So read 4 country cases. They are all simple. So it should be easy for you to read. And after that class, we go into midterm, right? You go into midterm. So we'll just not have a class in that midterm period. But on 25th, right? Whatever the Tuesday that comes after, we will have the movie quiz, okay, on the contract. And you know what movie to watch. So, okay, thank you, and I'll see you next week.